right, good afternoon, everybody. I am quite pleased to be joined by my longtime colleague, Jim Shepard.
Hi there.
And Jim and I have worked together since 2005, so we're not far off from our 20-year anniversary. Jim and my wife at home. So today's webinar, this should be fun. This is a topic that we deal with a lot in our office, non-compete agreements. See a lot in healthcare and in other environments. Jim and I have both been involved in some heated disputes and litigation involving non-competes over the last couple of years, especially. There's a lot of misconceptions out there about non-compete agreements and the enforceability. I think a lot of people think just that they're carte blanche, not enforceable, and in fact, that's not the case. But there is a push, and there has been, and Jim and I have discussed this for a while, there seems to have been a trend over, I think, the last couple of years to move away from strict enforcement of non-compete agreements in other jurisdictions, and even in Florida, it's hit or miss on what kind of response you get from the courts. What do you think, Jim?
Yeah, I mean, Florida's typically has been one of the more stringent of the non-compete states. So when even 10, 15 years ago, you had Florida and some other states that were very, friendly towards non-compete agreements, and then you had a lot of states that were not. But I've seen in Florida more of a trend over time to, it used to be they would be almost automatically enforceable. And then over time, they stopped being as enforceable as judges started really looking at, well, what am I trying to do in enforcing this non-compete?
And that's been, we've had some success in enforcing them. We both have drafted them for clients, and the same types of questions and issues tend to come up. Here's an issue. Jim mentions how Florida tends to enforce them. A lot of people look at the backside of a contract and the boilerplate provisions that I think clients misconstrue as always meaning the same thing. And I had one of these issues come up a couple of years ago where it was a company from up north that had employees in Florida, and but they had a governing law provision. I think they called for New Jersey or Massachusetts, somewhere that did not typically enforce non-competes, and they wanted to enforce a non-compete, and they ran into issues with it. But if you're under Florida law, we tend to see them as being enforceable.
Yeah, what I find with most of my clients, or when we're talking with them, is if there is an element where you're going to lose clients or customers because of the person moving to a competitor, then you're much more likely to get an injunction entered and enforce a non-compete. Where you run into problems, and we're going to talk about it shortly with the FTC rules. One of the things they found was that 1 out of 5 employees is subject in the country to a non-compete, and that's a lot of employees. And what we are finding is, and I've had examples of this, where they're trying to enforce a non-compete against somebody who's in an administrative function, or somebody who's ordering the materials for the warehouse. And they go to someplace else to order materials for the warehouse, but it's the new employer's own clients. And what we found in those circumstances is actually really hard to enforce a non-compete, because the judge is looking, okay, what's the legitimate business purpose, which is the keystone in Florida for supporting the non-compete.
That's right. And let's give the folks our agenda for today. We've kind of already jumped into an introduction. We're going to focus today most of our discussion on the proposed rule that the FTC issued in January. It would be 16 CFR 910.1, and I think it's 1 through 5. It's a pretty short rule. The proposal has a lot of explanation with it, and under that rule, non-competes would essentially be barred at the federal level. It's gotten a lot of response. The initial comment period, so when the FTC announces a rule, or any agency announces a rule, they have a comment period. The comment period originally was mid-March, and then
now
they
it's
extended it
to late April,
and now it's April 19th. And so they'll take comments to April 19th, and you can go to the FTC website and see what kind of comments people put on. You could make a comment on the rule, and I suppose they read through those comments, and they when they finally, if they adopt the rule, which I tend to think this one will be adopted, then they publish it in the Federal Register, and they have a response to comments, and some of those comments and the FTC's response and explanations on those comments, those will be the basis for the future litigation over this rule. What do you think are the odds that this is going to be legally challenged?
100%.
100%.
100%. And with the rule that's currently drafted, it will probably be somewhat different by the time they actually finalize the rule, because they're going to take into account the comments. There are some issues you're looking at going, okay, that needs some clarification, but I think they're going to adopt it, and then there's going to be litigation over it.
I think the day it was announced, I don't know if it's the U.S. or a federal chamber of commerce came out and said it was illegal and they were going to challenge it right away. And then I was just looking at an article. There's some hospital groups that have said they're going to legally challenge it. And
I would be very surprised if this does not end up in the Supreme Court.
The hospitals are worried it's going to drive up healthcare costs.
Yeah.
So that's always been,
and that's the reason why it's more in the hospitals, but it really is this FTC rule, because yeah.
I think it could be the most controversial rule since the ACA.
Could be.
I think so.
Yeah.
There's a lot of comment on it. So presumably, if you've joined us today, you're familiar with non-compete agreements. Perhaps you're in a company, or you have a company where you seek to enforce them against employees. Perhaps you're someone who is subject to a non-compete covenant in a contract, or something that looks like a non-compete covenant. Most physician employment, I'd say probably every physician, I'm trying to think if there's been an exception, but pretty much every physician employment agreement that I recall, I look at a lot of them, I think they all have some type of non-compete covenants in them.
Right. And most of the case law that actually you've seen over the last 5 years on non-competes, a high percentage of those deal with healthcare issues.
Often healthcare, it's often, and they're the folks, you have maybe the resources to fight it. Sometimes these get enforced because somebody can't fight them. And then we've had some carve-outs recently in Florida specifically with respect to healthcare on what's enforceable. And of course, the lawyers have our own carve-out, because the ABA, the American Bar Association, was kind enough to come out and comment long ago that it's not fair to have lawyers not have clients not be able to pick their own lawyer, so lawyers shouldn't be subject to non-competes. Florida follows that, everywhere else follows it, so the lawyers are pretty much safe for the most part.
Which I've always found strange, that they can't interfere with your right to pick your lawyer, but they can interfere with your right to pick what doctor you
pick
have.
your doctor, exactly.
Yeah, and I'd switch it, because
and we'll talk about the alternatives to non-competes, the non-solicitation agreements, where the language in those can greatly affect how stringent they are as well. So other restrictive covenants. So here we go, talking about what is similar to a non-compete. Of course, non-solicitation covenants that prohibit the solicitation of employees, or prohibit the solicitation of clients or patients of your former employer. In other words, if you leave, can you go back and try and take some of the patients with you? That's always the big concern, I think, with a lot of employers.
Right.
And what's your feeling on those versus strict non-competes?
Well, and you'll notice that we'll talk about the FTC rule basically says that it doesn't bar non-solicitation agreements, because there seems to be, okay, you're entitled to protect your clients, your customers, your patients. And it's just the FTC's couched in terms of its unfair competition to prevent an employee from leaving to go work for somebody else in service of their clients and their customers. And so, yeah, I see that as being a carve out that's going to continue. So as non-solicitation, I think that is where you can get injunctions, and that's going to continue. And
I think we've talked about trying to steer our clients more into a non-solicitation type arrangement than a non-compete, and asking the client, what's your interest in trying to, why do you want the non-compete? Clients say, look, I want non-compete language. Why do you want that? Well, I'm worried about losing patients. I'm worried about losing employees. If somebody leaves, coming back and taking more employees with them, then you can accomplish that with a non-solicitation.
But if your sole goal is to keep this guy from leaving your company to go work for a competitor because you don't want him to leave, that's more problematic.
And what about remedies? So you mentioned injunctions, but we've also had talks about alternative remedies. My feeling is that courts are more reluctant to enter injunctive relief than monetary relief if somebody does take patients or take clients.
Right.
You tend to, are you still of that mind, or
That it's like more likely for the do an injunction?
to get it, it's more likely to get enforcement on monetary relief. So in other words, if somebody violates a non-solicitation provision and takes patients with them or takes clients with them, that you'll pay over to your former, if I leave the employer, I take patients, I'm going to pay that employer 25% of whatever revenue I generate from those patients, because I took the patients right from the employer. So the employer still has an interest. So the employer says, okay, I'm not going to sue. I'm not going to try and keep you from working or keep you from working. If the patient wants to pick their own doctor, that's fine. Patient can pick the doctor, but you're going to, because I created that relationship, it's just like if I did the marketing for you, I set you up in that revenue stream. So now as a former employer, I should get some of that money. So I
Right.
get monetary damages.
Yeah, and we have talked about doing more of that, and that is I think, much more enforceable, especially if you can kind of couch it almost like a liquidated damages provision.
Right.
Because then you don't have to get into a whole lot of discovery as the value or whatever. You've already established each patient is worth X percentage or X number of dollars. And then it's just the simple math of this is how much you owe. And you find it's much more enforceable, and it still has the effect of making employees at least think about before they leave, and they do some business decisions. And if they do leave, well, they're going to leave probably anyway, but at least you get some financial compensation for them leaving.
And we tend to think, I think we're of the same mind, that we think that that's a good alternative of something that's maybe easier to enforce or more streamlined to enforce than pure injunctive relief, which can be tough to get. And the other thing with injunctive relief is you have to have an evidentiary hearing on the injunction. If you get an injunction, it comes as a shock to a lot of clients that if you're successful in getting a preliminary injunction, you've got to put up some cash for a bond.
Right.
And so you figure out, okay, what's the bond amount? And that bond's going to be based on the potential damages that would occur for the party subject to the injunction if it turns out that the court later says the court was wrong. So if the injunction was entered improvidently, that bond is there to protect that party subject to the injunction, and that can be a pretty large number, and there's no sense in trying to get an injunction if you're going to be subject to $1 million bond, for instance, and you don't have the wherewithal to post it.
And then the other issue with the injunctions is sometimes you're trying to convince a court to enjoin this activity, and so you get issues with what's the language of the injunction. And then there's always going to be efforts by the employee to work around the specific language of the injunction. So you're almost going back again. Is he violating? Is he not? Whereas if it's a money damages, it's just, okay, he owes X and you go collect X from him. And that may be enough to dissuade him from trying to take clients because he can't afford to pay X.
Right. So some other alternatives we have up here on the screen, obviously, confidentiality, non-disclosure agreements. Those are going to be generally enforceable, especially in healthcare or any type of professional services. But in healthcare, you have a lot of confidential information. There are, of course, we should mention specific laws applicable to medical records, where the former employee who leaves, if you're a doctor and you leave, you have a certain right to access those medical records. We list in here also non-disparagement agreements that we see sometimes, and the enforceability is questionable, but I tend to like those. They basically just say you're not going to talk bad about each other.
It gives you the ability to send a demand letter, stop talking bad.
That's
and then
right.
Usually the employee, when he goes sees an attorney, says, well, they may or may not be able to sue you on it, but just stop talking bad about them, because otherwise they may sue you just for the sake of, causing you problems. And most of the time that'll get the employee to kind of be quiet about what he's saying.
And yeah, most people, if somebody's got something to lose, then that usually has some good effect. As we mentioned earlier, non-competes are generally right now covered by state law, which can vary widely. California, for the most part, does not enforce them. I've seen trends in Massachusetts and or New Jersey, or both, when I was looking at this issue, where they were moving towards the garden leave enforcement or garden leave provision. where you can potentially get an injunction against somebody on a non-compete, but you have to pay them. And they call it garden leave because you're essentially paying people to go home and tend to their garden. And then you have places like Florida and Nevada, where I also have practiced and licensed to practice, where non-competes are generally enforceable, but there's carve-outs again for the attorneys and for certain physicians. And in Florida, that exception is in I should know if that's 501.335, I believe is the statute, but it's a provision that essentially it was passed about 2 years ago, and it basically says that if you are a medical specialist and you're the only specialist group, there's only one specialist group in a rural area in Florida or in a county that's considered a rural area in Florida, non-competes are going to be unenforceable for during that period while there's only one group, and for a period of 3 years until another group comes and forms a practice in the same area. So you can look at the specific language for the to see exactly what the rule says. But that was the case that was tested that and was upheld, and where the law was upheld was a federal court case, involved some radiologists out of somewhere near Fort Myers, Sarasota area.
And I expect we're going to see more of those kind of carve outs for the medical profession, because like you said, there's a lot of non-competes. And
yeah, and we've seen some that are really sort of silly, and we'll probably talk about those as they go along. I had one client who there was no risk of him actually taking patients because he was a specialist, and so all his hospital business was coming from internal referrals. So nobody was going to see him as a primary care physician, and his non-compete, I want to say off the top of my head, it was 40 or 50 miles from every location in this particular hospital group that I won't mention. But it essentially meant that he had to move from here in Central Florida, and he had a daughter in Lake Mary, and he had to move either to North Carolina or right in one specific area on the banks of Lake Okeechobee. And those were his two choices in the Southeast United States. And it was just silly, and it wasn't going to be enforceable, and we were able to negotiate around it. But it's interesting what people try to pass off as enforceable. So, the topic of trying to ban these, the rule that came out from the FTC, it's nothing new, not a new concept. There's been proposed statutes in Congress, or proposed law in Congress over the last several years that has come up and never really gains any traction. And apparently that was one of the arguments that National Chamber of Commerce argument. They said they were going to challenge because, well, Congress has considered this and they haven't passed a law, so it's beyond the scope of the FTC's authority. And if they pass this rule and try to enforce it, then we're going to come back and say this is really the domain of Congress. I don't know how successful.
Well, that's the non-delegation doctrine that Supreme Court, it's been kind of there's some, apparently when you read some of the decisions, a lot of the new justices want to revisit the non-delegation doctrine. And what that basically means is Congress can't delegate to the executive branch, i.e. the FTC or some federal agency, the legislative ability to legislate, basically, because that's kind of what's happening. Congress is so kind of dysfunctional now, trying to get anything passed through legislation is impossible. So they pass this kind of general legislation, and then the executive branches, agencies will say, okay, based on this general legislation, we're going to go all these specific, rules and essentially laws. And so essentially the FTC the argument is the FTC is essentially passing legislation. And since the Congress can't delegate that to an executive branch, they either have to do it, and if they don't do it, then the agency can't do it. And that's why I think this may end up back in the Supreme Court, because there's a general sense that the new justices want to really tighten that in and make it more difficult for Congress to delegate these issues to the executive branch, so they don't have to politically deal with it. That's kind of what's going on.
And we're sure to see it. You're probably right, Supreme Court. But another basis for litigation, whether this rule passes or not, and I'm of the sense that it will pass, whether they enact this rule or not, if you look at the statements that have come out from the FTC and the executive order that told the FTC to use its rulemaking authority to pass a similar rule, look at the November 22 policy statement from the FTC. That's the last bullet on the slide on the screen, where the FTC, under Section 5 of the FTC Act, expressed the view that essentially non-competes were unfair methods of competition in or affecting commerce. And that's what gives the FTC the authority to potentially regulate these if they do find that it's an unfair business practice or unfair competitive practice. And in Florida, we've got the Florida Unfair and Deceptive Trade Practices Act. And what do you think that's a mechanism for challenge if it hasn't been already for competitors and other businesses?
I think that's, as I think we were discussing earlier, that's going to add a potential another layer. I mean, anytime you try to enforce a non-compete, you're always going to get back the claim by the employee that you somehow breached the employment agreement, that maybe you didn't pay him the wages that he was due, FSLA claims. This will be yet another, some attorneys are going to start using the unfair trade practices as a defense. They're going to argue that your non-compete is an unfair trade practice. Now, it's going to be very difficult if it's more of a non-solicitation or the client's actually taking customers. But in a lot of these other situations where the employee is just moving from one administrative role to another administrative role, the old employer isn't suffering any recognizable actual damages. They can't point to we've lost clients or our revenues have gone down, but we still want to enforce this non-compete. I could see an unfair trade practice claim coming back by both either the employee and or his new employer, because the new employer say you're trying to prohibit competition and me being able to compete with you by hiring qualified people to do my work. That's what I think you're going to potentially see and so it's another thing you got to consider when figuring out how you want to enforce your non-compete.
Yeah, and companies often want to go after, I think both of us, our experience has been that companies will want to go after other companies who hire their employees and think that they're violating a non-compete. I tend to look at it in two ways. One is, are you just going after another company that hired your employee? Or two, that company, and we see this in healthcare, and I've dealt with this, I'm dealing with a similar issue right now, where it looks like another company is hiring employees because those employees are bringing patients with them.
Right.
And if you think, okay, hey, every time I hire one of these employees, I can bring on 5 or 10 new patients and bring them into the practice, that could potentially create problems. But if it's just a matter of trying to create a situation where your competition can't hire your employees, I think that's a problem.
Right.
And so now, and then we'll see it as unfair competition, unfair trade practices. So the other reason we don't think the FTC rule should have come as a surprise is because before they announced it, they had already taken action against some companies up in, I think they were all up in Michigan, and they entered into settlements. It was 3 actions that were announced on the FTC website, and in each circumstance, they sued for anti-competitive practices and called these non-compete agreements coercive and exploitive. And with the common thread among each of those claims is it was against general laborers and line workers. It wasn't specialists. It wasn't people. These weren't folks who were taking business away from the company when they left. They were just being paid at a potentially lower than market rate. There's the fact of inflation over the last year or two should come as no surprise to anyone. And so they had folks locked in the low paying jobs. I think one of them was a window manufacturer, and the FTC went after these companies, and they ended up entering into settlement agreements with them. And then right after that, then the FTC announced this notice of proposed rulemaking. We're going to dig into the rule. And the rule itself, and if anybody wants a copy of the rule, we could have dropped it in the slide, but if you email us afterwards, if you want to see a copy of the rule, or if you want to see it, the notice is about 200 pages and has commentary and explanations on why the FTC did this, and some commentary that'll be helpful later for potentially enforcing or challenging the rule. The rule itself is quite short. It's only
3 pages.
it's
2.5 pages.
And it basically defines a non-compete clause as, a common definition of a non-compete clause, something that between an employer and a worker that prevents that worker from going to work for a subsequent employer in a competitive area within a certain geography. Usually we see it within a certain geographic area and a certain line of business. And then worker, we bolded that there because worker is broadly defined, and it could be an employee, it could be an independent contractor, anybody essentially who's subject to an agreement with someone where they won't be able to go work for someone else because purely based on a competition issue. And the FTC was in the rule and in the explanations that accompany the rule, they do explain that you can still have non-solicitation agreements. You can still have other types of agreements to protect your intellectual property, to protect your patient relationships, to protect confidential information relationships. But they have adopted, and I think we'll see this on the next slide, a function over form type view and analysis is what they encourage with respect to the rule. And if the rule passes, it will be unlawful to maintain a non-compete clause and enforce it with an employee or a worker, or to represent that they're subject to one. And it goes even further, and we'll talk about it. You'll have to give notice to your employees.
You got to rescind it, yeah,
and rescind them and take them out. So non-compete clause definition here, this is right out of the rule. It's the contractual term that prevents the worker from seeking or accepting employment with any other person operating a business after the conclusion of the worker's employment with the employer. We sometimes see language in agreements, and the FTC didn't talk about this. I didn't see any discussion of this, that you can't work for a competitor while you're working for that particular company. Most of the time that would seem to be almost common sense, and I think that would be upheld if you're working with one medical practice and they say you've got to devote all your time here, you can't work with another practice. But I wonder about it for part-time employees. I wonder about it for in healthcare, for coverage and locum tenens situations where you're essentially an independent contractor. I wonder if this will have any bearing ultimately on independent contractors. If an employer can say, as long as you're doing work with us, you can't work with any competitor. What you think about that at all?
I have not really considered that. But yeah, I think that I suspect that's something that will get addressed as part of the commentary when they come out and start looking at specific examples. And I would imagine that would be if you're an independent contractor working part-time, I would guess that would be something to be negotiated who you're going to be working part-time with. Because again, it's different when you're actually working for the employer and then you're trying to work also for a competitor.
Yeah. We see that a lot. A lot of physician contracts that I look at have language that say you have to devote full-time efforts for the employer. You can't, no moonlighting without approval. And there's some legitimate reasons for that. One, if you're full-time and you're on call, then that employer is going to expect you to be available all the time to work for them, especially if they're paying you for that.
Right. And there's liability insurance questions. I mean, if you commit malpractice while you're working moonlighting somewhere, but can that come back to bite the employer?
Yeah.
The employer said, wait a minute, it wasn't something we were authorizing him to do. So,
and we had that issue a couple of years ago, represented some physicians in an action in South Florida where the physicians were moonlighting, doing some work with a telehealth company. And that telehealth company and all the folks working for it ended up in litigation, and the employers didn't care for that. So we saw folks lose their job, their main employment, because they were working with another company.
Right.
And then the FTC says, while they say you still can have non-solicitation agreements and other types of agreements, they will look at the language of the provision in the contract rather than what it's called. So in other words, if you can have something called non-solicitation, but if that non-solicitation provision is really more akin to a non-compete type provision, then it can still be challenged. And that's typically the case.
Yeah, because a lot of times you'll have the non-solicitation will be so broadly defined as to include prospective clients.
Right.
which is anybody who's made an inquiry for you over the last 2 years or something like that, or existing clients includes, patients you hadn't seen for 5 years. I've seen one recently where that was one of the issues. I mean, you didn't see the patient, last time you saw the patient was 5 years ago. That's not, I think that's where the FTC will, try to say, no, that's not appropriate. They use non-disclosure so that the employer can't argue, well, you have a non-disclosure, so you can't disclose any information, which could be very broad in doing your new job, which essentially prevents you from doing the new job. And it's it's disclosure stuff that is common knowledge. That happens not infrequently.
And so we won't be able to draft any agreements probably that say you can go to work for whoever you want. You just can't treat any prospective medical patients in Seminole or Orange County for the next 5 years.
Yeah.
And then this interesting part, and I see this as another hotbed. I don't know if I should mention this, but another hotbed of litigation. Somebody's going to jump on these like they jump on car accidents here with our tort reform. Employers are going to be required to rescind existing non-competes they have with employees and to provide notice. And there's a form that they actually provide for notice in the proposed rule. The employer will be required to provide notice to employees that essentially says you're no longer subject to a non-compete agreement or a non-compete covenant. I can totally envision a situation where this rule passes in I don't know, let's say June, and then 6 months goes by, and then in January of next year, you have all these companies that don't have a regular relationship with lawyers or haven't attended the seminar or just aren't really paying attention, and they have a bunch of workers under non-compete agreements, and now here come the class action lawsuits.
All right. That is the one area when I was looking at the rule where I saw, okay, this is something I'm anticipating is going to get a major rework, because the notice requirements are actually pretty onerous in the FTC rule. I mean, you've got to go back. It includes past workers, but I don't believe it really details how far back you have to go. So if you got an employee, do you go back if they're no longer subject to the non-compete? Do you still have to give them notice because it's been more than 2 years or more than a year? Do you still have to give them notice? What if you're a new owner? You just bought the business. You don't even necessarily know who the past employees are. I could see them extending the effective date for the purposes of giving the rescission to maybe, a year or maybe a year and a half, so that it gives people the opportunity to, most employees will just get out, ex-employees will already be out of their non-compete time. And so then you don't have to worry about trying to give notice to ex-employees. It would just deal with, your current employees. But yeah, that's an interesting, the whole giving notice and rescission.
Yeah, and we'll carry forward to subsequent. You raise an interesting issue with subsequent employees. We've seen it's quieted down a little bit, but there's been a flurry of private equity picking up small groups, hospitals picking up small groups, and when you bring those into the fray, I'm often surprised how disjointed large employers looking at employment agreements among different medical professionals from the same employer,
Right.
How different they are. And the reason for that, I suspect, is because they all came from a different, smaller group and they're subject to that same contract. So if you pick up those groups, you raise an interesting point. If I buy a company, or if I bring somebody into our group and now they have all these people who are subject to non-competes.
Well, and it gets worse, because there's a lot of companies that have long-term employees. So they've been there for 10 years. They signed the non-compete 10 years ago, but it's buried in some file somewhere. I mean, I can't tell you the number of times we've asked, give me a copy of the signed non-compete. Well, I got to go try to find it. I don't know if we even had one or not. And, so now you're asking employers to rescind non-competes they may not even remember they had. And so I just think there's going to be some issues and some change with all that.
Yeah, that's going to be another hotbed of litigation. So if you're trying to figure out what to do with tort reform, maybe that's your answer. And then there are some carve outs in the rule itself. The most notable is this carve out for the sale of a business, which makes sense. Nobody wants to buy a business. Nobody's going to buy your medical practice or law practice or an accounting practice if they think that once they buy the practice, they're really buying their way into those relationships, that you're going to leave and you're going to open up a competing shop across the street.
Right.
So I think that totally makes sense, and we see that we already see that in policy. Law reflects public policy, and we see in Florida and in Delaware and in other states where the typical non-compete language will say something to the effect of, anything over 2 years is presumptively unreasonable and unenforceable, but that extends to 5 years for in connection with the sale of the business.
Right. And it was interesting that they limited it, though, to the seller's got to own at least 25% of the business, because I could see circumstances where, your high-end salespeople, the guys that are really generating the business, they may only own 10% of it. And so you're buying the business and you're wanting to buy the business with this salesperson, but now that salesperson's not subject to anything, even though he got a part of the sale price. So I'll be curious to see if it stays at 25% or if they end up using some other percentage or other formula to determine who should be subject to a non-compete in the event of a purchase of a
That's a
company.
good point. That'll be an interesting one. Maybe we can go on and make a comment about that. And because what about a physician practice group with 6 physicians who all own equal interests?
Yeah.
Right. Or 5 physicians all in equal interest. We sell the practice group to you. We sign a non-compete, and then we turn around and talk to our lawyer and say, well, you each only own 20%. So the non-compete's not enforceable. You want to open up across the street, start advertising.
Right. And that ties into the whole non-solicitation, because while non-solicitation agreements are enforceable and will remain enforceable after the FTC rule if it's enacted, it just prohibits the solicitation. It gets much more murkier when you say, well, I didn't solicit this patient, they just came to me. Well, if you're out there advertising, patients are pretty savvy. They can figure, oh, you're at a new location, I'm just going to go there. So you haven't solicited them, but you're still doing the work, and the seller or the old employer or the people that bought the business are still suffering.
Yeah.
So it's going to be interesting to see how that plays out.
And that's kind of the hook. I think there's a comment, a slides. That's one of the issues to really be careful with non-solicitation type covenants, is whether it prevents you from soliciting former patients, or whether it prevents you from working with them at all, that you just can't do work with a former patient. And the enforceability, that may be questionable as well.
Yeah, I mean, I think based on what I'm seeing of the FTC rule, I think it would probably fall into, you can be prevented from soliciting them, but if the employee or if the customer comes to you on their own, it's a non-enforceable restriction, because that would be essentially non-competition, and which kind of, in some cases, makes the whole non-solicitation not that valuable, because again, people can find people on the internet so easily.
And it also makes me kind of reflect back on the rules as they apply to lawyers, because if you can have non-solicitation, but you can still allow people to pick their doctor, and if you can have, instead of injunctive relief, you could have monetary relief, you kind of wonder why it wouldn't apply to lawyers, other than the fact that they're the ones mostly controlling the rules. I don't know if I'm undermining ourselves here or not. So your opportunity to make public comments, last we checked, it was April 19th. Again, these public comments are available for viewing if you want to look and start reading. When I looked over the weekend, I think they were up to 18,000 comments or something. Actually, we've even included the link for you, so you can go right there and post. But there are some interesting issues that the FTC has actually put in a proposal. They raise questions about, should it apply only to certain types of workers, executives, or hourly workers? Should there be an exemption for executives, for high-level salespeople, for professionals, for people who are closest to the clients? And then the interesting question raised about franchises and whether franchisees should be subject to non-competes, because they're not really workers. But usually, if you buy into a franchise concept, most people, not everybody, but a lot of people get into franchises because they want to learn the business, and they don't have much background. So if you buy a McDonald's, you probably haven't been much in the restaurant business, and you figure they've got a system that works. We're going to buy it, work that franchise. We learn the business, and McDonald's has a vested interest in making sure you don't leave and steal all our concepts and take them with you.
Right. And then, of course, that creates issues because if you get into a franchise and you do it as an LLC, as a company, and you are just an employee of the company, because it specifically says that you would still not be able to have non-competes with employees of the franchisees. And so it would just apply to the franchisee itself. Well, if that's just a corporate entity, that doesn't do you a lot of good because your franchise is just, that president or that officer or that employee goes and forms after learning the stuff. So I'm anticipating that being some issues.
Yeah, employees of franchisees, and we've seen some of those issues recently ourselves. So this is really something that's going to create more litigation, but it's just going to redefine the playing field, I think. We already mentioned a little bit of this, fact specific questions regarding non-competes. We already see the carve outs for legal profession and some, like what I mentioned earlier here in Florida for healthcare. There are some, I know that there are some similar type carve outs and exceptions in Nevada. I'm sure other states have some types of carve outs. And these are the types of things we may see more comment on in the rule. Income requirements. Yeah, that was when I scanned those cases that the FTC enforced and announced back on January 4th. The common thread there is these were all folks who were working at lower wage workers.
Right.
And that's tough. You hire somebody, you lock in a bunch of people at $15 an hour and then tell them they can't go anywhere else to work within 50 miles. That seems anti-competitive and unfair to me, but I'm not an FTC regulator.
Right. Well, and that ties in because you like for the FSLA under your minimum wage stuff, it mostly applies, or they try to apply it to lower wage workers. Your high level executives and stuff are exempt because they're entitled to get paid, and the idea is that they have more bargaining power. So I would not be surprised if there was maybe some of those kind of limitations on the final rule.
I could see that, and there's a difference between even with non-solicitation of it. There's a difference between a highly compensated specialist in healthcare, let's say, and a home health aide. And for having, I've seen non-compete agreements, or people want non-compete agreements against nurses, aides, and home health aides that are close to minimum wage. Sometimes just seems crazy.
Right.
You're not. I don't know what legitimate business interest other than having to not have to go out and hire people on a regular basis. I'm not sure what other interests would be driven.
And I'll be curious to see. I don't recall if I saw it in there, but in Florida, one of the legitimate business interests that can support a non-compete, and you've got goodwill customers. You also have specialized training. And that is all over the board as to what constitutes specialized training. I mean, I was actually in a case years ago where a car salesman for a major dealership went to go to another major dealership. And he'd only been working there a couple of years, but the dealership, the prior employer said, well, we have this specialized training program on how to sell cars. And the judge actually, even though it's the same training program they all use, and the judge says, well, that's sufficient to support the non-compete and prevent the guy from working for another car dealer. He wasn't taking any clients with him. He's just a guy that, you walk in, he's the guy that says, hey, let me sell you a car. And and I notice in here, I don't see that there's any exceptions for specialized training.
I think there's one thing that we talk about, and it's repayment agreements.
Okay.
And we've talked about that before. Because you do have a situation. We have a client a couple of years ago that would bring people in that were unskilled workers, train them, put them through a training for several months, 3 months of training with another 3 months of an apprenticeship, where for essentially they were paying that person for 6 months and the person wasn't generating any income or benefit. The only benefit was at the end of 6 months, they would have another qualified employee. And then the employees leave after 4 or 5 months. They get the training and then they take off.
And they take off to somebody else. It's a competitor. Now they're trained. The competitor can put them in and they start making money.
That's right. And just as an aside, when I was when I started my practice in Las Vegas, I worked for a large law firm there, and there was folks in Nevada is just a hotbed for lawyers. There's not that many out there, and so people were going off and forming their own practices. And I had some friends that went off and formed a smaller boutique practice. And when people would go, we were joking about it because people would go to them from law school. Law students would say, "Okay, how do I get a job with you?" They say, "Don't come work for us right now. Go to this." I could see the firm I worked for was Lionel Sawyer, which was a great law firm. It's not there anymore. They've been absorbed by a larger firm. But people say, "Go somewhere like Lionel Sawyer and get trained for 2 years, and then send me your resume."
Yeah.
And so having that type of situation. So what we would probably see more of are the FTC had a word for them in here, but essentially they're training repayment agreements. And if they are unreasonable, like if you bring somebody in and you're doing 3 months of training and it's costing you, you're paying them, maybe you're paying them, $3,000 a month to go through training, and then they leave after 3 or 4 months, you may be able to have a provision that says, well, you recognize that we're providing you training for 3 months and you've got to pay us back $9,000. But if you have a penalty provision that says if you leave within the first 6 months or first year, you've got to pay us back $50,000, that's going to create a problem.
Right. And it is interesting because the FTC seems to understand and almost be tacitly approving if you give specialized training and they leave, you can make them repay you for the cost of specialized training, because they make that as, okay, you can have that, you just can't make it so onerous that it becomes a de facto non-compete.
That's right.
So that's how employees are, you can't, it wouldn't support the non-compete, but it would support you, getting paid back by the employee for all the training you've given them.
And so you could probably still do. I see these are the alternatives. The FTC is not proposing to strike everything, and there'll be a lot of workarounds. Non-solicitation, as we talked about earlier, both of your customers, your patients, et cetera, and then your non-solicitation of employees. The garden leave type provision or the no work provisions in non-solicitations. Actually, I scrambled those up. The no work provision goes with the non-solicitation, but your garden leave is where a couple forms is. One, you just pay for a certain amount of time. I've seen somewhere it was proposed, or maybe a state enacted a law that it was 50% of your last 6 months, and then you could keep them from competing for the next 6 months. And we see that a lot in severance agreements too. So that'll be interesting to see if you sign a severance agreement with a non-compete provision in it and you accept income. So it's a bargain for arrangement with consideration. Is that going to be enforceable?
That's a good question. I hadn't thought about that, but yeah, that's because you're under the current FTC rule, all non-competes are banned.
But
There's a carve out for if you're buying a business, so there may be a carve out for part of a severance.
And maybe what you're doing is the severance is sort of reshaped to say we're paying you a lower wage to go home and not do anything else, but you're still on our payroll, and you're going to be on our payroll for the next 6 months. We're going to pay you X, and you're not going to work for anybody else. Now, I guess if you do that, then can that person? And we didn't talk about the other issue is at will versus contract. If I sign an employment contract that I'm guaranteed a certain wage for a certain period of time, can the employer keep me from working? And that might be a little different. So they seem like they kind of tie in together.
Or maybe that would be ground. I mean, because it doesn't say anything about the FTC about you being able to terminate the contract, so you don't owe him any money for the time period that if he's competing with somebody who's competing with you.
Right.
So I think that would be the remedy. Okay, the employee's got a choice. I can either go work for somebody else, but then I lose the benefits of the contract, or I can stay at home and still get paid the remainder of my contract.
And I could see tying these all together, tying a repayment agreement with some type of garden leave type provision at the end, that basically you try to lock people up. If it's in your business interest to do that, then it might be worth doing. If you have somebody who you're afraid that they leave, you're going to lose a bunch of patients, a bunch of clients. It's something that's common in churches because of the relationship that the pastor or whoever the leader of the church has with the parishioners. Is that oftentimes if the pastor leaves or retires or does something, there's an interim person who comes in and stays, and they're tasked to come in and stay for a year to a year and a half before the next person comes in. And then the person who leaves is supposed to not have contact with the parishioners for a certain amount of time. I know that because I was actually on a church board of trustees years ago, and I have a neighbor who does that. I know actually two people. There's a lawyer in town, his wife does that, and I have a neighbor, and that's what he does. He's an interim pastor. They come in just for that interim period to break the relationship between the first pastor and the new one. And so I said, suppose it would be a similar type concept, that you're paying somebody to sit at home for 6 months so that the loyal following that they have of patients or whatnot gets used to dealing with somebody else.
Right. And I could see if you, especially like your highly compensated employees or ones that you're really concerned about, take some time to think about drafting your agreement, and maybe you allocate, part of their payment or part of their salary or part of their bonus to agreeing that if they decide to terminate, they will not leave. And you could, and I wonder, or go to a competitor without paying you some amount of money, and you tie it to, yes, you're not going to solicit these people, but these patients, but they're going to come find you anyway. We know we're going to have some loss. So if you go leave, that's fine. You're going to be able to service those patients, but we've helped you develop those relationships on our dime, and we're going to require you to pay back X as a liquidated damages for this breach of the employment contract. That might get around the FTC rule, because you're not preventing him from going to work. You're just trying to recoup kind of your losses as a result of you helping him develop his practice, or her develop her patient practice, knowing that a certain percentage of those patients, no matter what you do, are going to go follow their doctor, because that's what people do.
I think there's going to be a lot of thought that's going to have to go in. This is going to pass, and there's going to be a lot of thought that goes into challenging these, but there's also going to be a lot of thought that has to go into how to write these in a way to make them enforceable and protect your business, and really protect your legitimate business interest.
And in a way that doesn't break the bank, because so often one of the issues with getting injunctions is it is an evidentiary hearing. So a lot of times you'll do depositions beforehand, you'll do stuff. So it is really expensive just to try to get the temporary injunction. Whereas what you're dealing with is just calculation of damages or an agreed upon amount that's going to be paid. He's working for a competitor. Very few contested, or there's very little you could do to contest whether somebody's a competitor or not. And now you've locked in what your damages are, and that gives you kind of a more easy in and out. All right, I've at least gotten paid some money because this guy left. And it does provide a disincentive in some cases. Well, do I really want to leave and I don't have to pay X? And it kind of creates, at least something you can work with your employee.
And one other point here on the slide that's worth mentioning, we've talked a lot about the employees and the relationships with patients and customers and so forth. But there's also, you see this more in technology, but you see a lot more in medical now. I'm seeing a lot of medical contracts that refer to intellectual property and have some work for hire type language, and some that I've seen some that even say that any intellectual property that you develop while you're under employment with us is ours, regardless of whether it was developed in the scope of employment or not. And the implications for some, especially some specialists or people that are really into technology, or physicians or just other professionals, is that you may be approached, or you may have an idea to develop a software, an app, some type of new product that you may be contractually bound, or you may have signed something in an agreement that gives that over to the employer. And the same token, or on the other hand, I suppose, the employer may be hiring employees to develop intellectual property and come up with new ideas. And you don't want somebody, you see this in software development, somebody who develops something leaving and just going somewhere else with the same ideas. That was the big case of Google, and was it Google and Waze, I think, a couple of years ago, where they took trade secrets. So it's a little bit different angle. It's not dealing with people, but they also consider intellectual property and the effect there. And then finally, I think we're kind of right on time here for any questions. 12:56. If you have questions, you can fire them out to us in the chat, or I don't know if we can open it up. If we haven't hit something that you had a question about, if you wanted to hear something today, or if you think of something later, my contact information and Jim's contact information is on the slide there. Maybe we can do another one of these in 6 months or so.
Go to the last slide, please.
Yeah, when the pardon me, sir. There we go. There it is. There's the contact information. but maybe do something in 6 months or so when
Six,
when the
9
rule
months
comes out,
after that
whenever
rule has actually come out and the initial
the
litigation's been
first few
filed.
lawsuits are
Yeah.
filed on it.
Because it'll come out next day, there'll be the lawsuits filed.
Let's see, I think we got, we do have a couple questions, so if you have any, fire them out here in the chat. If the FTC rule goes through, does it go into effect immediately? Good question. They'll probably have a date certain, but I think, what do you think?
With the moment the rule goes into effect, that's the effective date. They'll have the 180 days. Unless one of these lawsuits gets a federal judge to put an injunction to stay the enforceability of the rule while the lawsuits go through, I would hazard there's a pretty good chance you're going to have an injunction entered by a federal court that's going to say, okay, we're going to stay the rule until we figure out some of these issues. But it might not. So you'll know once the rule's done and the initial lawsuits are passed. Like I said, I suspect that 180 days is going to move to 365 or something. I think they're going to extend the effective date to give people more time to digest and accomplish what's going to happen.
But it's also going to change the dynamic of non-compete enforceability and non-compete litigation, regardless of whether it goes into effect or not. I think even now it's going to, because you're going to see more people that are challenging non-competes, and you've got to be thinking about this when we're reviewing contracts or writing contracts or arguing over them. We've got to be thinking about, what's the trend, and I would expect that an argument that you'd see pop up now would be, hey, the FTC is already looking at these things as though they're exploitive and what was the other word that they use? Unfair and deceptive claims under Florida fiduciary.
Right. And that's what we talked about a little bit earlier. It adds another layer to it because, Florida has a Deceptive and Unfair Trade Practices Act. And a lot of times judges and claims will refer to FTC decisions as to what is unfair and deceptive on a whole range of issues for commerce. So now you have yet another FTC decision that says non-competes can be deceptive and unfair because they're anti-competitive, because they're exploitive. And so that's what I would anticipate you're going to get on some of these lawsuits. The plaintiffs or the employees' attorneys are going to say, wait a minute, this is unfair. FTC has already ruled and said it's unfair, and this is why it's unfair in this particular circumstance.
Yeah. I think that if I were approached by a group of, let's say, home health aides or hospital workers who were maybe not high level or highly compensated employees, but lower compensated employees in a hospital group or in any type of environment subject to a non-compete where it really doesn't look right, citing those FTC cases and what the FTC enforcement was in those cases that came out in early January.
Yeah, I mean, because the FTC had a whole findings of fact, including 1 out of 5, and it depresses wages, and so that's just going to go right into what your motion is going to be.
Let's see, any chance of the state of Florida amendment to the Constitution to negate non-compete and non-solicitations? Amending the Constitution?
Yeah, I mean, it's hard. It could happen, but you'd have to get somebody pretty powerful on board to really want to make it happen, kind of like when Morgan really got on the marijuana because it's really expensive and really difficult to get enough signatures on the ballot and then to get it even submitted. And then even when you get it submitted, the Florida legislature will typically try to figure out how not to comply with if they don't like it, they'll have to find a way. So it could happen, but I wouldn't bank on it. I think that's something that will have to just be legislated.
And if money controls politics, which a lot of people would say it does, and there's views, whatever your political views, I think most people view the conservative Republican right as more business friendly, and the liberal left is more worker friendly. In that environment, it seems like the businesses that have the money would have the resources to push through their own, if they wanted to go through the Constitution, push through something they would call it the let's ban non-compete rule, but when you actually read the details of the rule, it would have a whole bunch of carve-outs that applied to whatever that special interest was. So right. it would be essentially enforcing the rule. This is one of those instances where maybe democracy, I think we're going to close out here, but general sense of non-compete, I feel like they're abused. What do you?
I agree. It's like we've talked about. This is why you're getting these kind of FTC rules, because they've been abused. I mean, there's a lot of good things of non-competes, and they are perfectly legitimate in some circumstances. But what's happened is a lot of employers are then using it just blanket for everybody to try to capture these employees and say, well, you can't leave because you got nowhere you can go work.
Yeah.
And that's why I think ultimately in 10, 15 years, the landscape will look a lot different from non-competes, I think.
All right, I think that wraps us up for the afternoon. Thank you again. Thanks to Jim for joining us today. I do this pretty regularly. I love doing it, but it's great to have Jim on board today. And any final comments as we close out?
Nope, this was fun.
All right, have a great rest of your day, everybody. Thank you.